Welcome, everyone. My name is Jeff Beach, and I am the President and CEO of Asthma Canada. I'm very pleased to have you with us today for this session on planned giving, will, and estate planning. Wills and estate planning aren't necessarily topics that people enjoy thinking about. They can often feel complicated, confusing, something that we just would rather deal with later. But having a plan in place is one of the most thoughtful and caring things that you can do for the people you love. And it's easier to start than you might think. So tonight we'll be presenting a friendly, no pressure webinar to walk you through the estates and the essentials of estates planning in a simple and approachable way. Whether you've never written a will or already have one and want to make it more meaningful and update it for your family or the causes you care about, this session will give you clarity and confidence to take those next steps. This webinar is the first in a two-part series on the topic. The second one will be taking place on the 18th of November, and there will be more information provided in the chat on that throughout the evening. A few quick housekeeping notes. This session is being recorded and will be available on our website soon. We'll be sending a link out to everyone who registered to receive the recording, so don't worry about capturing notes. You can obviously if you'd like, but don't feel pressured to do that because you will get a recording of this session. All attendees are muted, but please try to type your questions into the Zoom Q&A feature if you have questions. We'll cover as many as we can in the Q&A at the end of this session. If you have any asthma or respiratory allergy questions, please contact our asthma and allergy helpline, and you can visit us on our website at asthma.ca. With that, let's get started. We'll start with a land acknowledgement. I'd like to begin by acknowledging the Indigenous peoples of all the lands that we are on today. We're meeting virtually, but it's important to pause and reflect on the significance of the lands that we all call home. We recognize that those joining us are doing so from various lands and territories across the nation. Quick note about asthma in Canada. And as you can see, asthma affects millions of people, over 4.7 million people of all ages. And for some, it can be very severe. It's not common. It's not just common. It's serious. And it leads to emergency visits, hospitalizations, and even deaths every year. Beyond the personal impact, asthma carries a huge cost to our healthcare system and our economy. These numbers remind us why prevention and better management, including vaccination, are important. Very quick note next about Asthma Canada. We do everything we do to bring back one simple goal: helping people with asthma live healthier and fuller lives. We focus on three pillars: education, advocacy, and research. Education to empower people living with asthma, their families, and healthcare providers with the knowledge they need to stay safe and thrive. Advocacy to drive stronger policies, better access, and real change across the country. And research that fuels the innovation and discovery, bringing us closer to a future without asthma. Next slide, please. So a quick disclaimer for this evening's session. This presentation does not and is not intended to constitute tax, accounting, or legal advice. The contents are intended for general information purposes only, and under no circumstances can be relied upon for decision-making in specific circumstances. Attendees are encouraged to consult with a qualified accountant and lawyer to seek advice concerning the specifics of their particular situation. With that, then, I am pleased to introduce our speaker for this evening, an expert in tax and estates, named Karen Slezak. Karen is a partner with Crowe Soberman's Tax Group and leads the firm's Estates and Trusts Group. She is also, and we're very fortunate to have Karen as the treasurer of Asthma Canada on our board of directors. And with that title, she's also the chair of our Finance and Audit Committee. So Karen does a lot, including offering this session, but behind the scenes, even a lot more for Asthma Canada. We really appreciate that. And with this, I'll turn it over to you, Karen.
Thank you, Jeffrey. Well, I hope that everyone out there is like most of us here. We're all basking in the joy of that win last night with the Jays. So let us take that forward with the energy it did. And this is a topic that's a little more serious, but as you see, we'll go through it and help make this less of a topic that seems scary and make it more of a topic that you can really use with you and your family. So what I'm going to cover tonight is starting with, what is estate planning? People like me will throw it out. Let's look at your estate plan. But a lot of people don't really understand what that entails. The estate planning that you do does change as you go through the different stages of life. And I'm going to just go through an example of what people in their 20s and 30s may be planning for, people in their 40s and 50s, and then those in the more mature years, let's say 70s and 80s. I mean, this doesn't mean that this fits for everyone, but at least gives you an idea of how estate planning does change. We'll also go through the main components of what is in an estate plan. And one of the key ones is your will. So the question always comes up, well, do I really need a will? And what happens if I don't have a will? And we'll go through that as well. We'll also look at a checklist for items you'll want to consider for your will before you go and work with typically a lawyer to get the will done. And the last item is charitable giving, because as you'll see, there are some significant tax benefits if you'd like to be involved in supporting causes like Asthma Canada. And you'll understand better as to what you could do in your will to benefit the causes as well as reduce your taxes. So what is estate planning? A lot of people think you prepare a will if you're good and you've done a will, and then you put it in the drawer and it's done. And there you go. You never touch it again for the rest of your life. Estate planning is not just doing it once and for all. It's an ongoing process you need to go through because you want to preserve your money. You want to transfer your money in a way that's very orderly and effective for your family. So proper will drafting is just the foundation of your estate plan. And as you'll see, there's a lot of other components that you need to consider. From a tax perspective alone, you need to work with someone on how to minimize your taxes to the extent you can, or at least defer your tax. If you've got, say, a spouse or common law partner, there's great opportunity to at least defer your tax until they pass away. So let's take a look at how estate planning might change over the years. And as I said, I'll break it down here for some of the things a young family looks at, a mature family, the middle-aged family might look at, and an older family. And thinking back for everybody here who's either got grandchildren or children, or, remembers going through those stages, or maybe is going through them now. Typically, the younger family between 20s and 30s, they're starting to accumulate assets because up to that point, they may have been paying off debts, schooling costs, getting a first vehicle. There's usually a lot of paying down of debts. But this is the time when they may be starting to work and build up some money. It's a time when maybe they're starting a family. And the main assets are typically assets in the registered type accounts. And what do I mean by that? That's the tax-free savings accounts, known as TFSAs, the registered home ownership plans, the RRSPs, which let you save for your retirement, and if you have children, an RESP, which is an education savings plan. They're all set up by the government to allow you to get money into those plans, and then they grow. They grow without additional tax while the money is in the plan. So frequently, people in their 20s and 30s are concentrating on starting to build wealth by putting money into those plans. This may be a stage for looking to build up money to acquire either a condo or a townhouse, but life has changed a lot. I mean, things were very, very different when I was growing up and could acquire a house and what I would pay, and to the size of a house cost and mortgage right now in Toronto, which is astronomical. So it's a very interesting and very difficult stage for kids in that age range, and they're hardly kids, but to build up and try to buy their own property. So things that a will would be useful for at this stage are typically focused on some of the more rudimentary items. Who is going to be the executor? And an executor is the person who's going to take care of managing your estate after you die. They're going to collect all your assets, they're going to pay off your debts, and then they're going to follow your will in terms of how things are to be settled. Like, are you going to just have things passing outright to family or children or siblings? Or are you going to have young kids and you're trying to hold things in trust till they're older and able to receive that money? Now, a more mature family, somebody in their 40s or 50s, we're now looking at a point where it's often a peak period of building up assets. I mean, this is a time when there's a lot of high growth in assets, both because money is being put away, jobs often pay more, and the investments themselves have grown. It may be a time when someone's gone through a separation, a divorce, maybe they remarried, maybe they're now living common law. There are a lot of reasons here that people need to look at their estate plan when their personal situation has changed. Their life becomes a lot more complicated if it's blending together two, or I'd say two families. In the mature stage, I often see a lot of people looking at a second property. So that could be a cottage, it could be a Florida condo. So that's also a reason to think about your estate plan, because that's an additional, more complicated asset to consider how it will ultimately be taxed and how it will transfer to the family. The final thoughts here is you need to look in this stage more at the performance of your investments, because now you need to be considering, will they be enough to carry you into your retirement? And what do you need to put away to start thinking about your ultimate retirement? So you want to look at your advisory team and your will more frequently. Let's take a quick sip here. And finally, my example is the older family. Now, this is someone who's often approaching retirement, or maybe they're even in retirement. Unfortunately, one of the frequent themes is that they do have health concerns, medical concerns. And so ideally, even ahead of this stage, they should be looking to budget for potential healthcare costs. Because if they need round the clock care in a nursing home, retirement home, it's pretty expensive. So ahead of this, you really need to be looking very carefully at how that's going to be funded. At this stage, the assets they hold have peaked and are actually typically drawn down to fund a lot of those tax costs and healthcare costs and so on. Now, while I wrote on here about, get advice about minimizing tax, of course, at every stage, it's useful to minimize your taxes and speak properly to someone who can plan with you, an accountant, a financial advisor. Make sure that you are looking at your taxes now, and also in a worst case scenario. What if you do have an untimely, unexpected death? And here's a time also to now speak to the advisors about whether a charitable gift in your will would make sense. So I'm going to tell you one little quick example that people don't think about. I've got somebody, let's say it's me, and I have two children. And so my thoughts are, okay, say my husband has died, I'm going to leave everything to my two kids. That means two people to inherit my estate. Well, guess what? There's not two people. There's the CRA and then my two children. That's three people, because the CRA comes in and they scoop their part first. And then what's left can be split between your kids. So you have a choice. Do you want to let the CRA take a piece of your estate totally off the top? Or do you want to consider making a gift to a charity of your choice where you're supporting the causes that you want to support and the CRA's portion shrinks? So that's part of why we're promoting this as well. So what are the main components of an estate plan? as I sort of touched before, a will, because it's going to set out your desires from, as we call it, even from beyond the grave. What would you like? What are your wishes? Who's going to run your estate? And ultimately, who's going to inherit your estate? There'd be income tax planning and probate planning, and they're not the same. Income tax planning is what I said, CRA comes in there and they want their piece of your taxes on death. And probate. And probate is a different kind of tax. It's a tax on the value of your estate, and it's a tax on trying to get your will authenticated before the courts. And they charge you 1.5% of the value of all assets. Now, don't get crazy about probate planning when maybe some of the things you would do would hurt your income tax planning, because even income tax planning, I mean, its taxes run between 25% and 50%. So chasing a 1.5% tax item, sometimes it actually makes sense to pay the probate. Trust may be incorporated, designations on accounts like your RRSPs and TFSAs, and the charitable giving we touched on. I will be covering more of these in the second part of our seminar series. So I am focusing tonight more on what is estate planning, and the next one is heavier on tax planning and how we can save tax through the charitable giving. So let's just double back for a moment, because here's the fundamentals. Why do you need a will? We've touched on some of them, but this will names your executors. And if you have children, it also will let you provide who would you like to be the guardians of your children. It may include funeral instructions. Some people don't do it that way, but some do. You may choose, instead of designating on your, let's pick one here, RIF, who the beneficiary is, you can actually put that directive in your will. One of the key pieces here, it'll specify who are your heirs and how they're going to receive their inheritance. Is it just simple and you say, I give to Bobby and Joey and Sally, and there you go? Once the estate's wrapped up, all the taxes paid, everything collected, boom, 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 3 beneficiaries. Or you could look at it and say, Bobby, Sally, and Joe are 12-year-olds and 15-year-olds, and they shouldn't have this much money at this age. So that's where trust comes in. That's where somebody else will manage that money for them until they reach certain ages. And you get to specify what those ages are. So it's used for that purpose. Helps you deal with complicated assets like foreign ones, and it ensures a common law partner inherits like a married spouse. And let's go through that. If you do not have a will, the government does have rules for your estate. It says, okay, if I leave a married spouse with no children, the married spouse gets everything. Okay, that doesn't sound bad. But what if you're not married? Your common law spouse does not have automatic rights to your assets. They do not have that. They have to apply and make an application that they were dependent on you for support. So you could have this scenario. You leave a married spouse, let's say, and one child. The first $350,000 goes to your spouse, but the rest gets split between your spouse and your child. So if things would not work out the way you wanted, and again, if this is an unmarried, as in common law spouse, yeah, it gets very complicated. Oops, on here. If you don't have a spouse and you don't have issue, and that means children, grandchildren, things revert back to your parents. And finally, if you have no parent, no one like a parent, a child, a sibling, you're going to find it all goes to the government. That's what this is, sheets to the crown. It goes to the government. So I'm sure none of you want that scenario to play out. I even had a situation where a fellow was living common law with a lady, and they had been together a very long time, but they did not have a will. He died, and all this big stock portfolio went to his parents. Now, they were very honorable people and they gave the portfolio to his partner, surviving partner. But the tax rules were very different on death. If he had left it in a will to her, we would have deferred the tax until she died. They call it a rollover. But because there was no will in place and they went first to the parents and then back down to the surviving partner, we had to pay all this capital gains tax on death. It took a big chunk out of her inheritance, all when they could have just got a will done. And wills, at the end of the day, don't have to be complicated in that scenario. Oops, I'm going the wrong way. Sorry, folks. You really should think ahead before you go in and sit down with a lawyer. And I highly recommend you do sit down with a lawyer. I get that question a lot. Do I really need to do with a lawyer? Can't I just write up my own will myself? You can. You also have a very high chance, I'll be blunt, of screwing it up, of paying a lot more money because you chinced a bit on good legal advice. I've got that right now. Someone who wrote up his own wills actually didn't do that bad for a 2-pager, but we ended up having to pay thousands of extra dollars in probate fees because of the way he set up his will. So penny wise, pound foolish. I am a firm believer not to use the will kits, not to skip the wills, not to do a handwritten will, pay the money and get it done properly. So in a checklist there to think over, who do you want to run your estate, i.e. the executor? Do the executors, if say it's 1, 2, or 3 kids, are they all residents of Canada or is anyone living outside the country? Because if anyone is, that makes it more complicated as well. And you get too many of them outside the country, you could pull the estate into taxes in the foreign country. Say, for example, the US. You named only 2, let's say, of your kids down in the States, dear old Uncle Sam and dear old Mr. Trump may want to have some income tax being levied against your estate. You'll want to think about who are your ultimate heirs, which we call beneficiaries. If you've got minors, then, like we talked about, a guardian. Who's going to be the guardian for them? And if there's a decent amount of money involved, then again, who's going to manage the money? Because if you do not step up and put someone down as being the person to do that, to manage the money, then there is an office in the government called the Office of the Children's Lawyer. And they will step up, they will hold all the money and make only certain payments. And then when your son or daughter is 18, they release it all. Well, that's a couple of problems. You don't want somebody else running your family's money. And that could be, again, a large sum to give an 18-year-old. So with children, it's very important to have a will. And if the child or parents or brother, sister, whoever is disabled, you don't want to miss the opportunity to set up some special disability trusts, which we will talk about again in November. And they protect that person so there's adequate, supervision of the money and what is paid for, but there's also some wonderful tax breaks. And, again, the will checklist is all about taking an inventory of your assets because that's what the executor will do. They'll need to look at what have you got, where is it, what taxes or debts or anything has to be paid. And then once they get down to the net amount, the residue, then they can look at what's going to be shared. And in this part, like I say, I would not be shy in looking at charitable giving as a way to cut down both your taxes and do a wonderful thing to help wonderful causes. I am in a new office tonight, and I've learned that if I don't move enough, the lights go down. So if you're seeing the lights come up and down here, that is what's going on. So I apologize for that. So the 2 parts, as I was saying here with this, the gifts you leave in your will can be one of 2 items. They can be a specific what we call legacy amount or a residual gift. And a legacy amount is typically as worded here. You would say something, and you trust me, you'd kind of give the instructions to your lawyer, but they would write something in your will saying, I give, bequeath, devise, those are all pretty much legalese words, to Asthma Canada or the charity of your choice, the sum of X amount of dollars. Could be $5,000, could be a much bigger number, and it's to be typically used for the organization's greatest needs. I mean, you could specify something, but typically people do not. They leave it to the charity to do what they would like, unless it's an exceptionally big gift. The other one to look at is a gift of the residue, which I was saying was the residue is the whole pot of the estate, less the taxes, less the bills, until you get down to the core of what is left. And then designating that a portion of that, or all of it, I've seen some where people don't have family, is given to a charity. And because of that, in both cases, there is a charitable tax receipt received by the estate, which then reduces the taxes on the final tax return. I think some of this may be repeated here, but let's go over it again. So your cash resources, by specifying something in your will not be affected during your lifetime. I mean, you're still able to use your money, and it's when you pass away that this pot, this final residue, is determined. And, you know, especially if you speak to the charity that you're involved with, if it's a residue gift, you can certainly support the causes that they're supporting. The tax parts here, the government has made this very, very favorable for a number of years. In a nutshell, your estate does receive a tax receipt for the value of the gift once that gift is finally made. The receipt can be claimed against all, i.e. 100% of the net income on your final return. And you could even amend the year before death. This is up to the executor to do the work on this one. So you will typically find that the tax savings from the gift is up to 47%. For people in the top bracket, the taxes you pay are 53.5%. So you think, well, why don't I get 53.5%? And the challenge is the Ontario government doesn't give you a full credit. So 47.5, which still in most cases does a really good job on bringing the tax deal down to almost nothing. And if that is still a problem, because not everybody has all the income on the final return, the receipt can also carry over into up to 5 returns that are filed after death. Many cases, there might only be 1 or 2, but just so you know, there is that opportunity. Those are state returns. So, as I said, instead of the CRA coming in and taking a large portion of the taxes, that money in that you want can be used to benefit the different causes that you wish. So next month, and we'll open up shortly to questions. Next month on November 18 will be our second webinar called Smart Estate Planning, Reducing Taxes While Leaving a Legacy. And I'll do a deeper dive into different types of charitable giving, how they're done, especially around an RRSP or RRIF. There's a couple ways you can make a gift of those. Stocks, like securities, we call them, stocks and bonds, how to make a gift of those, which is very powerful because we're able to eliminate the capital gains tax on those stocks or securities and also get the benefits of the donation claim. We'll look at life insurance. That's another option. If you have an existing policy or are thinking of taking out a policy. And of course, we talked about the residue bequests. And also, just still working on this one, I'll do a little bit also for people that have corporations in terms of what their donation might be like. So let me turn it over to Jeffrey again for a moment on the wrap up, and then we'll take some questions.
Thanks so much, Karen. That was great. We decided to split this into two webinar sessions because there are a lot of complex issues being discussed, but I think you did a great job, Karen, at boiling it down to the essentials and what people need to consider and why this is such an important topic. As I mentioned at the outset, it's often something that we just naturally don't want to think about, don't want to deal with. We always think we have lots of time to do it, but some careful planning in advance can really make things so much easier when you do eventually pass away. So thank you so much for that, Karen. For those that maybe joined us a bit later, Karen is our expert presenter, Karen Slezak, who's a partner with Crow Soberman's Tax Group, leading the firm's estates and trust group. She's the treasurer of our board of directors at ASMA Canada, and she has vast knowledge, as you can see, in these topics, which allows her to work with clients on most topics pertaining to their finances, including tax minimization, real estate, tax planning, charitable gift planning, corporate and partnerships and restructuring, effective use of family trusts, planning related to estates, insurance, any number of items, anything to do with tax and estate planning. And on a personal note, both of Karen's children have struggled with asthma. So that was one of the reasons why she became involved in volunteering with Asthma Canada, because she supports the initiatives that we do in order to help families understand and control this disease. So thank you again, Karen. We really appreciate that. And we do have some good questions that have come in. So we've got some time now to run through some of those. As I mentioned earlier, if you have questions, please feel free to type them into the Q&A on your Zoom. It should be along the bottom. If you scroll down, you'll see a menu down there and there's a Q&A button. Please feel free to ask any questions. As I also mentioned at the beginning of the session, if you have very specific questions, we would advise that you reach out to your own estate lawyer or an accountant, tax accountant like Karen, or to Karen herself if you're interested. And we're certainly happy to provide her contact details along as well. So questions that have come in, I'm just going to start from the top here. And one of the things that you mentioned, Karen, in your presentation was about a scenario where maybe an executor is living overseas. So this person says that they were thinking of, they have a child, a daughter who lives overseas, and they were thinking about naming that child as the executor. So do you have any thoughts about that with her being overseas? Would that create problems? Anything to consider in that type of scenario?
Yeah, don't do it. Yes, because most likely when you say overseas, they've ceased to be a resident of Canada. I mean, it's sort of embedded into this question. And the odd chance that they were still a resident, it wouldn't matter. But if they have ceased to be a resident of Canada, you're going to make your estate a non-resident of Canada. And that's very complicated. Extra rules apply to non-residents. So even as simple as earning income by the estate until you get everything wrapped up will be subject to special withholding tax at source. You try to sell a house, you have to go through a much more complicated and costly process to notify the government as a non-resident estate that you're selling the house. And again, special tax withholding applies on the gross proceeds unless you file special forms to get it down to the net proceeds. And trust me, I do a lot of those. It can take up to a year to get it sorted up with the government. I know that it's possible that a bond will have to be posted to allow for the individual to take instructions. The courts may require that even to do probate. So typically it's not a great idea. That's all the Canadian side. And then, as I said to you, it's like now you could be pulling the estate into taxation in the other country. And strangely enough, like there is not a clear cut here as to how you decide then which country should the estate file for. So just keep it simple, like say they are in the US wants to tax this estate, Canada still wants to tax this estate, and there's no tiebreaker rules in our treaty. And they suggest taking it to a form called competent authority, but that's a very complicated process and costly, so people don't typically do it. So, yeah, I think you got to think twice. And typical rule of thumb is to keep it as a Canadian resident entity. So people will continue to appoint a few others in the family, or even consider a trust company, something like a trust company executor with this non-resident child.
Thank you. That's why we need you. That's why we need people with your expertise, because something that sounds so simple and straightforward is not when it comes to these types of matters. So,
Yeah.
bottom line there is don't do it. That was your first answer, and I think you explained why, but that's the
Yeah.
thing to consider. Another question that came in from one of the participants, again, someone who has a child living out of Canada, uh, that they intend to have own the condo that this child is living in after this person asking the question passes away. So, as the co-owner of a condo, would it be best to have a child who's living in this condo now become a co-owner while this person is still living, as opposed to going to probate and then throwing into, complications into the matter after the person asking the question passes away? I hope I didn't flub that question too much.
Yeah, I may have to kind of get a little clarity on that one. So the child is living in the condo,
Yes, but not owning it. So the
not
question
owning it.
is,
Yeah.
would it be beneficial for the person who owned the parent to make their child a co-owner so that after they
Yeah.
pass, that transfer of ownership is smoother?
Right. And so this is an example of what I was saying. I mean, that will work for avoiding the probate because now as a co-owner, the property will pass because of the joint ownership. It's not something that's passing through the estate or through the will, so therefore probate's not paid on it, which is a plus on that side. The things I also look at though is this a secondary property? Or is it something that it was the parents' primary residence and you're now messing up part of their principal residence exemption? Because as soon as you put a child on as a secondary party, the government sees it as if you disposed of half the property. And fine, okay, it's my principal residence to start, so that's half disposed. I got an exemption, that's fine. But from that point on, only half the property has an exemption. And what's going on for the child at that point? Do they have a second property? So there's not always straightforward on that one too. I can't give you a one size fits all answer on it. But I'd be careful. I mean, you're sort of chasing again the probate savings, and you got to look at the principal residence exemption to know if it was worth doing.
Right. Yeah, suffice it to say, it's complicated and you need specific advice on that.
Yeah.
Thank you, Karen. Question came in from a participant around making a will and if that person should consider a healthcare directive as part of it. So she says, and if I have an executor that will take care of my death expenses, do I need to give him power of attorney at the same time?
Great question. I didn't cover the two directives. Is a power of attorney of for financial items while you're alive, but has somebody step in as your power of attorney when you're no longer capable mentally, physically to look after your own money and affairs, get pay your revenue in, pay your bills, etc. And then there's a second one that's a power of attorney for healthcare matters. So no, there is certainly no reason that you have to make the same person the executor of your will. The person, especially making your healthcare decisions, is often family. And, unless you really don't have family there, but typically people have a child or a couple of children, and you want them to decide what's going on in your healthcare decisions and know whether you want to resuscitate or not resuscitate. So that's one piece taken care of. They may not be suitable to be your financial powers of attorney. That's more of what you got to decide. Are they suitable? You're right that there's sort of a natural synergy if they're going to continue on into being your executors. Um, it sort of depends on your background. That was my situation, but then I'm an accountant. So for my mother, I could be her financial power of attorney and moved on into being the executor for the estate. So they're different roles. One's going to be involved with the estate part, and with the power of attorney is, yes, definitely you want those in place as well. long before they're fully needed is excellent too. So when the time comes, and it did for my mom, it came very, very suddenly. And we were glad that my brother and I that we got and had it in place. It was very simple to get it activated. So that's the main parts of the three: your executorship, your power of attorneys, and the healthcare power of attorney.
Thank you. Another question here I'll read that came in advance of the session. I'm not really sure I have enough assets to need an estate plan. Is it still worth doing one?
Yeah, and I think it should hopefully been similar to what I was trying to describe for the, and maybe it's a little hopefully not fully unrealistic, but typically when I was younger, yeah, I didn't need things the same for an estate plan. And so, I could get by with just designating my RSPs. I wasn't married then. I didn't have a house, no children in my life. So you can certainly simplify it down into what's really needed at different stages. Um, Certainly, as I said, certainly when you're starting to build up some wealth, at least make sure you've designated your registered plans, RSPs, TFSAs. And if you're starting to pick up and build some wealth, yeah, you do want at least a will in place. It could start as simple as that. It doesn't have to be extremely complicated until your life circumstances change. You're getting married, you got a child, then they don't have to be in that order. You got a child, you're getting married, life's changing, you're getting sent overseas. It's when you've got some of these bigger changes. You got a house, you got an unexpected inheritance. Those are the times you want to look at, well, is it time to get a will in place?
Yeah,
Um,
exactly. And I think one of the things you said towards the beginning of the session was around at the end of the day, who do you want deciding what happens with your assets and how your estate is handled? And that's to me, that's one of the number one compelling reasons is you want to have that control and you want to be able to make sure that whether you have a large pool of assets or whether you don't have a lot, what you do have is going to be treated as you want it to be. And that's a really important thing to keep in mind.
yes, I agree.
In terms of online will platforms, there are a lot of them out there, and we actually have on our website with Asthma Canada, we have an example of one an organization that we've done some partnership work with for people who want to go that route. First of all, is it worth doing that and then maybe having a lawyer review it, or do you think if you're going to have a lawyer review it, is it just better off to go with a lawyer right away?
Well, I know the lawyers are very open. If you've taken one of those platforms and started down the road of what you want, then it's sort of like when someone comes in to see me and they've already got all their tax receipts sorted out and they know what they're doing and so on. You're like, okay, let's just go. So I don't think you get any resistance from the lawyers to do it, to use that as a stepping off for what's there. There is a place for them, as you say. I've just seen too many times it does blow up and backfire for what the person did on their own. But if this is a more sophisticated organization and what they're doing and helping people do, then certainly that's a different type of organization than trust me, this other state which is paying through the nose because of what they did and did not do.
Yeah, exactly. For if someone is a married couple, does it make sense for them to have a shared will, or should each person have their own?
Well, okay, now this one is there is no concept of a shared will.
Okay.
Yeah, out there. Okay, so you can't do it that way, but we'll often see very basic wills where each person needs their own will, and the wife may designate typically a husband as or partner, whatever, the husband to be her executor. That simple. So she dies, she wants her husband to step in to manage the money and the property is coming over to her. And in the event he's not there, let's say it just goes to their three children. His will be the mirror image, but the other way around. He'll name her as the executor, he'll leave everything to her, and again, out to the same three children. So they're two different wills, but they could mirror each other as how they'll work and what's going to happen. They're not, by the way, they're not cast in stone. I mean, if he passes away first or she passes away first, I mean, the other person has the right to alter their will, change and alter their will. So that's also another reason we'll talk about later about why trusts come into place. Because for more wealthier people, they'll say, well, if I go first, I want to make sure that my spouse here doesn't remarry and I see the money go out to some stranger. I want to make sure that the children we've done and made and raised and so on ultimately inherit the money. But I don't want my wife to like live in poverty in the meantime. So we will set up a spousal trust, put the money in there and let money flow out to her during her lifetime to support them, but ultimately it goes to the children. So it's sort of an extension of the will is to create these trusts as a way to still, we call it sometimes controlling from the grave, but it's it still protects the family and is used a lot in second marriages now when that's going on.
Thanks, Karen. Another question that just came in Ontario, I heard that you can have multiple wills. When would a husband and wife consider that?
Yeah, now this is where I wondered if the other person was getting at that when they were talking about husband and wife in the same will. Yes, it's quite common. It all arose back in 1989 in a very famous case called Granovsky, where the Mr. Granovsky had a very, very wealthy company. And he was holding the shares of the company, and the company had loans to him. We call them shareholder loans. So instead of putting them all on the document for probate, adding up that 1.5%, the lawyers looked at it and said, well, you do have the right to have two wills. Let's say one in Canada and one in Florida, dealing with your Florida property. Everyone said, yeah, that's true. And then they said, well, why can't we have one will for all the items we have to get probate on, like bank accounts, certain properties like certain real estate, things that someone wants, typically somebody at the bank wants certification through the courts that this is a valid will, the final will, not being challenged will. And they won't budge. They're going to want probate. But private companies and private debts from those companies doesn't need probate to transfer those shares. It doesn't need it. So legally, they can just immediately go to their surviving spouse, partners, whoever's going to inherit. So that's what they did. They broke it up into items that do need probate, the ones that don't need probate, and it's a way to eliminate probate fees on the very, very, very valuable assets in these estates, being the shares and debts. So long story, long answer, but it's something we commonly do. We commonly do. Amazingly, the government came out with the official name for it, a state administration tax, and I've lost track of when. And we all expected them to shut that technique down, and they have not. So still out there at this point.
It's still there. It can be
Still
used.
fun.
Yeah. Thank you. Are there some common mistakes that you see people making when they're writing their will? What sort of pitfalls do you often run into that you would suggest that people try to avoid?
Yeah. Let me see some of the best ones. Again, is some of it is not seeking professional advice to do it. And and this ties back in the story I was just telling you about the probate. The one I said was the very, very messy estate, wrote his own will. He didn't do double wills. He wrote one nice single will, which I had no problem with, but he should have done double wills and we wouldn't have had his estate pay all these probate fees on the corporate assets. So I see it as just, don't get chintzy there. Get some professional advice. And he has a very wealthy estate. I mean, there was no reason for him not to at least pay a little bit more and get it. So that's one. You've raised earlier the residency of the children or so on, or the executors of the estate is another good one. Not properly paying attention to that or getting advice about how they're going to deal with that. That's a good one. There's the odd time you'd be surprised where people forget to designate an RSP or a RIF or a TFSA. And so you're needlessly having it funnel into the estate. subject to probate. So you're paying fees you didn't have to pay. And I just usually say my advice is, yeah, work with some, take that inventory of what you have, what's going to happen in a hypothetical scenario if you pass away, and just walk it through. You'll find if you have any of these errors.
So we have a few more questions that we'll get through, and there's time to do a couple of more questions probably. So if you have any that you'd like to add, now's your chance to do so. Please use the Q&A feature as we've been asking you to do. Sort of a nice segue, I guess, your response in terms of one of probably the most common pitfalls you see someone not getting professional advice. How does one find a good estate planner if they don't have one? Someone who has, doesn't necessarily have a financial advisor or a tax accountant, someone like yourself. What are some of the ways that people might be able to find someone that they can trust if they don't have one now?
Yeah, I mean, the Law Society does have, if you contact them, they do have a referral to lawyers that are estate planners, and you can find everything from the sole practitioners up to the Bay Street lawyers. I mean, it doesn't have to be a Bay Street lawyer involved. Ask, ask people that you trust, who did they use? People at the bank can sometimes be also very good as to referrals to who they think are good people to use. I get it all frequently as referrals from number of it's all over the place. Financial people, lawyers as well. We kind of cross refer to each other. Your best shot though is usually ask a few people you trust if you're okay about that. I know it can be a sensitive topic, but just say like, hey, have you done something? Have you got somebody that you liked as a good lawyer, typical lawyer and accountant you're paying pair to talk to.
Okay, that's great. Good advice. So another question that just came in, if the person who dies does not have enough money to fund the estate to pay debt and taxes, what does the executor do in that situation?
It's usually a bankrupt insolvency for the estate. And typically, if the CRA is involved with what's there, then you need to yeah, it's different. You're not really working with a person like me. You really are working with a trustee in bankruptcy, which my firm does have. And I've got one of those too. I get all the problem cases. And he's got contacts with people at the CRA and told me sort of the process is, they often will lay it on the table what's there and come to an agreement as to what the different taxes will be settled for. And it won't be 100%. Maybe they are willing to say 30 cents on the dollar to settle up the tax bill on X number of years. So it's a different story. You'll have to work with a trustee and, typically a trustee firm in bankruptcy.
Okay, thank you very much, Karen. Before we wrap, I just want to come back to one of the central messages here that you've discussed and that we want to make sure gets out there, and that is about the value of charitable bequests in estate planning. I can tell you, as someone who works in the nonprofit sector for Asthma Canada, which is a registered charity, some of the largest gifts that we receive are through estates. We had just this past year a couple of very large gifts that came in because people did that sort of thoughtful planning in advance. And that's something that often can help people realize a larger legacy than they probably could have when they were alive. People are often sitting on assets, not necessarily sitting on cash. So you may not be able to make a large gift to your favorite charity, but you might be able to do something with the assistance of a professional that could really benefit the charities that you care about the most, while at the same time benefiting your family and the estate. So it really is a win-win. It can be complicated, as we've touched on throughout this session today, but with the right advice, you can certainly do that in terms of leaving a legacy and ensuring that your family is taken care of. So, Karen, thank you again so much. We would really appreciate it if everyone would take a moment to fill out the post-session survey. There'll be a link rather in the chat for the survey, which I just see it coming up now in the chat window. When we send out the recording, there will be a link for the survey as well. It always helps us to plan these types of sessions in terms of what people are interested in and what was covered, what wasn't, and will help us ultimately, I think, as well with the part two, if you will, of this series that we're running with Karen Slezak from Crow Soberman. So thank you again for attending. Thank you so much, Karen, for this and all you do for Asthma Canada. That second session will be taking place on November 18th at 7 o'clock Eastern Time. So please mark your calendars. You can register for that. We'll be posting a link for that as well. And we encourage you to share that with others, because this is a type of information, whether or not you're an Asthma Canada donor or have other charitable gifts in mind, it really doesn't matter. This information is the same for everyone. It's something that is an important topic for everyone to consider, every one of us, regardless of what stage in life we're at. So please share that information. And when you get the recording, send it out. I know some people had a couple of questions were asked about, how do I bring this up with my family? Maybe that might be an idea. Share the link to the recording and say, you know, I attended this session. It was really interesting. Here's some things that we might want to talk about. Food for thought. And again, thank you so much, Karen. Thank you everyone for joining us, and have a great evening.